One defendant claims he was never at the crime scene, despite fingerprints being found there. Another is offered a second chance through deferred adjudication, while a third is suddenly facing up to 20 years with no probation. Stay until the end to see how the judge handles each case, and which decision changes everything.
Well, John, this is in their place. We decided to go to Discovery with this.
It's 2 years old.
I have not been on it for 2 years.
It's 2 years old.
I think as long as
You didn't know it's been indicted. It was indicted in June of
What?
26 of 24.
Yes, sir. But I was
I don't care.
It's a different state.
2 years old.
I know, yeah. But I've only been on a very short period of time. So,
Well, you better get ready.
oh, yeah, I will.
All right. You're charged with a second-degree felony of burglary of habitation, which is too long. It's too old.
That's okay, sir. It hasn't been. Hasn't been in this court that long. I think he was in another state.
You're still at 6506.
Yes, sir.
Okay.
It was outstanding warrant for a long time, Your Honor. Then you got arrested and started the system. But it's an old indictment, but it's not as far as in the court system. It's relatively new.
It's an old indictment.
Oh,
The first time for somebody to show up 2 years after the event, it's already stale. And it's hard enough to make cases, put their things together after 2 years, but he's got a fingerprint at the scene.
That's correct.
But he says he's never there. It was a miraculous or mystical event. So, where's fingerprint? What do we do now?
Just 4 weeks.
You got it? Okay.
Thank you.
And Arturo Puente.
Right there.
What are we going to do?
All right, this is also one we got an offer that should work out. We just need to go over some stuff. And I think it's our second time.
You're charged, sir, with third-degree felony of evading arrest or detention, which carries with it up to 10 years in prison. And yeah, this one's about a year old too.
Yeah, that's.
Are you still at 2259? Why does this thing take so long?
I don't know. Last time we were here was our nickel. Our first announcement.
All right.
Was
Four.
you got
Good. Thanks.
stick around though.
Is it Melzamira? Melzamira Henderson. Here with Mr. Dusler, your attorney and the state's attorney does. The defendant waive a formal reading of the indictment and the arraignment here. Can we proceed in summary? Yes. Harley Harrington, did you get a resetting? You can go. Yes, ma'am. She didn't have the plea nor cue. Don, did you send it over?
Jimmy hasn't. He hasn't signed it yet. I don't need to stand up.
Okay. In summary, and the defendant waives a formal reading of this, we can proceed.
Yes.
In summary, this indictment alleges that on or about January 11th, 2026 in Jefferson County, Texas, you committed this third-degree felony of collision involving serious bodily injury. Do you understand what you were charged with here now?
Yes.
If convicted, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
In this case, an agreement has been reached.
Yes, sir. For deferred adjudication, no fine, restitution to be determined.
Uh, the agreement has been reached between the parties, you would be pleading guilty but not found guilty. You would be placed on what we call deferred or unadjudicated probation, so long as you follow the terms and conditions of probation, which are normal and customary for this type of offense. This can be up to 10 years in length. If you do well, it can be shortened to 1/3. If you fail, probation could be revoked and you could then be found guilty and then sentenced up to the full range of punishment. Do you understand what you're at all? Okay.
Yes.
How do you plead to this? Guilty or not guilty?
Guilty.
Or pleading guilty voluntarily. That is on your own free will and because you are guilty. I'm going to show you what's marked here as states exhibit
Yeah.
1. $14, man. Yes. Okay, I show you what's marked as States Exhibit 1. Did you sign that document?
Yes.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
States Exhibit 1 tendered?
No.
Without objection admitted.
Yeah.
Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged with any lesser included offense. You are giving up your rights to your jury trial or the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer and all true, so help you God. States Exhibit 1, part of the record for all purposes, pre-sentence reports.
Yes,
I'm going to follow this agreement if nothing further. I'm going to find, Ms. Henderson, that you are mentally competent to enter your guilty plea, and it is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But this court is going to postpone or put off all finding of guilt so long as you follow the terms and conditions of probation. Where your probation officer is going to go over all of those with you, make sure you follow them. And again, as I said before, if you fail, then your probation could be revoked. You could then be found and sentenced. You don't want to pile up your record, so do well. Also, there are going to be several terms and conditions of probation. Most of those are the kinds of things all of us have to do, like commit no crimes, avoid injuries, habits, things like that. But in your case, we're going to order a defensive driving class to be taken and paid for by you. Although that is a win-win for you. You'll learn how to be more conscious about your driving. Your insurance will go down because of successfully taking this class. So it helps you financially.
Yeah.
This is for 10 years. And again, like I said, you do well, it can be shortened to 1/3, which is 3 1/3.
So why can't you sit,
And also restitution, we have TBD, to be determined. I'm going to, you are going to be responsible for any damage or loss to a victim caused by your wrongdoing, but we don't know how much that is. We're going to, probation office will look into it, figure it out, and we'll come back later. And, or I will sign a supplement. And you've got to help put those people back in the position they were before they were injured as best you can. You can't undo pain, but you can pay for it. If it's your responsibility, you can't pay for the costs for their damage that was caused by your wrongdoing here. That's how you fix mistakes. Make a mistake, then you fix it. You move on and do better. Okay, please see the probation officer. Thank you.
Prior, here's.
Oh, okay, well, I don't know what I do with this. Is this for you file, I think, maybe?
Oh, we
I thought it was for the
Oh, I'm selling the off business. I don't,
Normally,
it doesn't-
changed his mind, Laura?
yeah,
yes.
Yeah, that was all control now.
okay, then, there is no deal. We're going to trial and, this is, third degree felony. It's also enhanced with this 2012 conviction. So he's looking at, 20 years with, no probation available. And that's what we'll do. Set this as soon as possible.
Every courtroom has a story, but not every outcome is what you'd expect. If you enjoy real courtroom moments, judge rulings, and legal cases explained clearly, hit subscribe and turn on notifications so you never miss the next case. Which decision surprised you the most? Let us know in the comments.